Welcome to Do It for the Case Law for Saturday, July 25th, 2026. Visit doitforthecaselaw.com to listen to more in-depth, per-case reporting. Today we are covering two federal appellate decisions across two reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to Michael for the Constitutional Law Roundup.
Thanks, David. One case in this block. The First Circuit denied the motion to stay a district court injunction pending appeal. That denial stands for State of California versus State of Alabama. Here is what happened. The lower court had enjoined federal defendants from implementing specific provisions of Executive Order 14,399 regarding mail-in ballot administration in plaintiff states for the November 2026 federal election. The government asked the First Circuit to pause that injunction while they appealed. The appellate court applied the in-Ken four-factor test for stays, focusing primarily on whether the government made a strong showing of likelihood of success on the merits of its standing and ripeness arguments. The court held that the government failed to make such a showing because the plaintiff states demonstrated Article III injury through concrete, particularized, and imminent harms. These harms included current expenditures of staff time and resources to comply with the executive order directives, as well as certainly impending financial costs from having to replace already printed materials. Back to you, David.
Thanks, Michael. Raj, you are up next.
Thanks, David. One case in this block from the First Circuit, and it was denied. The court denied the federal defendant's motion to stay the district court's injunction pending appeal on the challenge brought by the state of California against the Trump administration. Applying the standard four-factor test for a stay, the appellate court found that the executive branch failed to demonstrate a strong likelihood of success on the merits regarding their arguments that the states lacked standing or that the claims were unripe. The court reasoned that the challenged executive order imposed concrete injuries by forcing states to divert staff and resources for compliance, creating imminent financial cost from non-compliant ballot envelopes, and posing a credible threat of criminal prosecution against state officials. Back to you, David.
Okay, that is the Daily Rundown for Saturday, July 25th, 2026. Subscribe or follow for the next update. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction.